everyone, and welcome to our webinar on state lobbying regulations. We have two great speakers for our webinar today. Sonia Gioseffi is a partner at K&L Gates, and she counsels clients on a variety of regulatory and compliance issues, including on pay-to-play and lobbying requirements under federal, state, and local law. And she also advises sponsors of private funds on structure, formation, and regulatory issues. Desiree Moore is a litigation partner at K&L Gates and a founding member and co-lead of the firm's Digital Crisis Planning and Response Client Solution. And she counsels clients in proactively planning for and effectively managing crises. She also helps clients manage the risks associated with social media use. So thank you both for joining us today. As Megan said, please feel free to ask questions in the chat as we go along, and we'll do our best to get to those. With that, I'm going to turn it over to Desiree to get us started.
Thanks so much, Sarah. Sonia and I are grateful to the IAA for facilitating this program, and we're so glad to be with you all today. We look forward to jumping into what is going to be a robust program. As the crisis lawyer, I'm going to do what I do best and largely come in at the end of this program with some need-to-know information about planning for and managing crises that advisors might face. But in the meantime, Sonia and Sarah are going to talk to you about some of the fundamental items, the key things that you should be thinking about when you're doing business with, or even in the early stages as you're considering doing business with state and local pension plans. More specifically, as to our agenda, we're going to touch on lobbyist registration, focusing on an overview of the laws in this area. For gifts, we're going to talk about parameters surrounding and the implications of gifts in this context. We'll get into placement agent issues, including when placement agent considerations arise. And then we'll talk you through some other issues to consider, including pay-to-play, FOIA, and crisis planning and management. And then we'll round out the program with some key and tangible takeaways, some things that we want you to kind of walk away with at the end of this program. We have a lot to cover in an hour. So with that, next slide, please. And Sonia, let's get started with our first substantive topic, lobbyist registration.
Great, thank you. So I'll start with an area that is somewhat confusing, which is the lobbyist laws. And these are really confusing for two main reasons. The first of which is that this is a regulatory regime that was written for lobbyists. So you're applying a regulatory regime for one particular industry to another industry, which would be investment advisors seeking to enter into a contract. So there's just a lot of issues that come about, two different industries and regulations that were adopted for one industry and not the other. And the second reason this is confusing is that it's jurisdiction based, meaning that each locality will have its own law and then regulatory agency. So by way of example, the state of California, if you're dealing with a state pension plan like CalPERS, you would have to look to the state lobby law, which is regulated by the Fair Political Practices Commission, and the registration is done with the Secretary of State. If you're dealing with a pension plan for the County of Los Angeles, you would look to LA County law, so the local ordinance for LA County, and that is interpreted by the Division of Lobbying within the county. If you're dealing with LA City, you have to look to the city ordinance, and that is governed by the Ethics Commission for the City of Los Angeles. So you have different laws, and even if the laws are similar, you have different regulatory agencies interpreting them, which may lead to different interpretations based on the jurisdiction in which you're dealing with. There are also formal and informal positions, and these laws can change often. Next slide, please. So here are a few examples just to help you understand how these laws are written and how they can apply. So first is Ohio. So here a lobbyist is defined very broadly and would cover someone who is on a regular and substantial basis wants to influence the decisions of the state pension plans. Whereas if you look at Wisconsin, here lobbying is related to legislative and rulemaking activities, which wouldn't include entering into a contract. And then if we go to the next slide, we'll look at Pennsylvania, which has a broad definition of lobbying, which includes influencing That can mean indirect communications, expenses, or any types of gifts. However, if you go to the last bullet point on this slide, you'll see that there are specific exceptions. So if you don't rise to the level of the monetary thresholds or the hour thresholds, or if it's an RFP, you wouldn't trigger the lobbyist registration.
Sonia, one thing I wanted to ask you here, we get this question a lot. Are there certain jurisdictions that tend to be more challenging when it comes to lobbyist regulation?
I would say that they're all challenging, unfortunately. It's just because the laws are all written in different ways and there's different interpretations. The one thing that I think is challenging for people a lot of the times is understanding that there are the different localities that are going to have their own rules. So for example, the state of California, there are over 52 different localities. So if you say, hey, if we just want to learn about the state of California, you're actually learning about over 52 different legal systems in essence, which is just challenging to navigate. And so in the navigation, I'll go to the next slide, which is how I think about these laws. And Sarah, I think, did you have something to say? Sorry.
Right. One thing I wanted to mention here is that for investment advisor members on the IAA's website in the legal and regulatory library in the pay to play section, we do have some information about state level requirements. So wanted to mention that. But yeah, it sounds like with all these variations, it is helpful to think about some common questions to ask across these, when you're looking at different statutes. So.
Yes. So in looking at these, the questions would be, the first one is, who does this law apply to? Does it apply to the legislative branch, like the state of Wisconsin, or would it apply to any government agency? And if it applies to a government agency, is a plan defined as being a government agency? Some places it is, some places it's not. The second question to ask yourself is, who at the plan would trigger application of the lobby law? So would interactions with any employee trigger the application? Would it be the key officers, such as the chief investment officer? Would it be the trustees of the plan or some combination thereof? Third question to ask is, what action would trigger the application? And that Pennsylvania law is a good example of that, which is, is it how many contacts are there? Is there a time threshold by the individual making the contact? And is there any monetary thresholds?
Sonia, one point here is that I think sometimes people might think that lobbying just deals with spending money, but you make the point here in that bullet about amount of time. So it's not just necessarily dollars, right? It's also what activities you're engaged in.
Correct, and that could depend on the particular law. So not all laws are going to have the same requirement as to the time threshold, or may not even have a time threshold. But the good thing, if you do look at this in advance, is that you will be able to see what the time thresholds are, and to avoid registration, if possible, you would just have to make sure that the time of the individual contacting the plan is less than that threshold. Okay, so we'll go to the next slide. So another question to ask yourself are, in addition to the time and monetary thresholds, are what are the carve-outs? Are there any carve-outs for RFPs, discussions at open meetings, or negotiations once the contract has been approved? Typically, these are carved out because it's you're getting away from the idea of the back room, cigar filled room where you're unduly influencing a government official to make a bad decision. Rather, you're having open, transparent process. And so typically that would be carved out of the lobbyist requirements, or registration requirements, I should say. The fifth question to ask yourself when you're looking at the law is, who needs to register? Would it be the GP or the manager or the investment advisor? Would internal marketing employees need to register? What about the third-party placement agent if you're using one, as well as any employees of the placement agent? And finally, if registration would be required, is there any restrictions on contingent compensation? And this restriction may only apply to lobbyists, and it may also apply generally to employees or third parties. You just have to look at what the law says.
Sonia, what do you mean by contingent compensation?
It's a good question. Contingent compensation would be something that is when it's compensation based on whether a contract goes through or not, meaning that you would get paid if the plan enters into a contract, whereas you don't get paid at all if the plan doesn't enter into a contract. So next slide.
Do you see this more in the private fund context, that contingent compensation idea?
Yes.
Okay.
Yeah, I would say it's pretty much only in the private fund context. And
Thank you.
if it is something at your organization, you probably would know about it because it's the big way people are compensated. So this is something that definitely would affect people, and you know, something that people are concerned about if this is how they're being paid. All right, so what are the consequences of registration? You know, compared to being a registered investment advisor, they're very minimal. But you know, a lot of times there's some type of fee associated with it, which is usually a minor amount. The individual who registers as a lobbyist may need to take an ethics course. There may be that prohibition on contingent compensation, but the key here is really that you may have to do some type of disclosure reporting, and that's why I call this really a compliance headache. Because it's someone has to keep track of all the reports that need to be filed, and they could be filed on a monthly or quarterly basis. And then it's also the information that goes within that report would need to be filled out. So it's more just something that you have to do and keep on top of. So next slide. So here, you know, what are the you know, considerations if you do register or before you register. So you'd want to look at the requirements of the lobbyist requirements for prospective investors, because you may have to register prior to contact, or you could direct behavior to avoid registration if possible. And then, you know, just practically speaking, because there are a lot of compliance issues involved with this, you might want to limit who's in contact with the plan. So you have one person registered opposed to 10. And so you do one report opposed to 10 reports on a quarterly basis.
Sonia, on that point, one question we did receive ahead of the webinar was, you know, if I do have one person in my organization that's registered, am I covered? And it sounds like that's not necessarily the case. So that's why you need to think about who has contact. You know, it's not just necessarily one person. You know, you're good to go if you've registered one person, is right?
Correct. That's precisely right. Because even if there is stuff going on behind the scenes, you may have to fill out information related to that activity on those disclosure reports, depending on what the reports require. And then you don't want to inadvertently trigger registration if, say, your registered lobbyist is sick and is unable to attend a meeting, and you send a substitute in, and oops, now you just have to register the substitute. So it's, you know, that's why you want to stay on top of this and what the triggers are. And then with the next slide is a question that I get a lot from clients, which is, well, given all the hassle involved with this, why do I need to register? Like, what happens if I don't register? Which I would never advise doing, because first of all, you know, there's penalties associated with it. It could lead to, you know, a Form ADV disclosure reporting event. It could be deemed a disqualifying event for purposes of Reg D. I've never seen that either of these happen, but, you know, it's a possibility. And then there also could be, you know, contractual violations to the extent you say that you are in compliant with all laws. And then the biggest issue here, which Desiree will be touching on, is headline risk. And that's just something to keep in mind when you're dealing with any plans.
We did get one question that came in around contingent compensation, and that maybe could that come up also when a sales employee earns a commission on marketing other products and services like separately managed accounts? Have you seen it come up there?
Yeah, it could come up there as well. I mean, I normally see it within the private fund context, but it could also come up in a separately managed account context or for other services. I mean, the key here is just to review your contracts and make sure you understand how compensation is being paid. Because again, if you're stopping someone from getting paid as to how do they think they're getting paid, they're not going to be happy with that if they find out after the fact.
And then a kind of a follow-on question. Do these lobbying regulations, does it matter what kind of product is being offered to the client? For example, mutual funds versus separate account or private funds, do the lobbying regulations distinguish between those or not really?
The lobbyist regulations are not as sophisticated as to distinguish between private funds or separate accounts, unfortunately. But so that, they really don't get into the details. So it's more looking at the activity versus what words are used in the law. So if your activity rises to the threshold of lobbying, then you may need to register. But then again, you want to look at the exceptions and then see if even if there isn't an exception there, if it would make sense to not be registered, and then perhaps get clarification from the actual regulatory agency. To the extent you're getting away from that, the back room, cigar smoke room, right? If it's a more open process, then there may be an exception that would apply.
And Sonia, I'll jump in because you mentioned headline risk. And as I said at the outset, we'll get into crisis planning and response closer to the end of the program. But I think it's important that it comes up here as sort of a bit of a foreshadowing. It exemplifies, I think, why crisis planning and management are so critical. All of the legal implications that Sonia walked us through are things that we need to be attuned to, of course, and it's the crux of why we're here, in a sense, to learn what potential repercussions may arise from non-compliance. But on top of these consequences is the headline risk. You can think of it as like on top of or sort of underlying, each of these considerations is the headline risk. And it's a very real one, meaning that your non-compliance could land you on the front page of a mainstream newspaper or an industry forum, or as the primary subject of a popular investment advisor watchdog Twitter feed, which does happen to our clients a lot. We see a lot of repercussions sort of in the social media space, even more so than mainstream media. So where your non-compliance is considered, a disqualifying event, as Sonia talked us through, or you're banned from working with a particular plan, this can be big news depending on how high profile you are. And it's limiting in the immediate term, and then also in the long term. If somebody were to Google you and they can find remnants of a story about non-compliance, even years after the fact. So I think the kind of preliminary takeaway before we dive too deep into crisis planning and response is just that non-compliance has the regulatory consequences, and then also consequences that you might not necessarily be able to recover from a crisis communications and public relations standpoint. The headline risk can sort of also exacerbate your non-compliance at times, right? If trigger it if a whistleblower, goes to the press instead of the SEC or, whatever the, reporting agency might be. So, we'll talk about components of an incident response plan, kind of how you can prepare for and address a crisis shortly. But I just think it's a great place to highlight the risk and to start thinking about how we might anticipate and navigate a headline risk that kind of ties up with potential non-compliance. So from here, we'll transition into our next slide, please, which is gifts, another area that has a lot of kind of regulatory considerations that Sonia will talk us through.
Great, thank you. So just like the lobbyist requirements, the gift laws may appear in the state and local statutes. Unlike the lobbyist laws, though, there's often a layering effect, meaning that multiple laws could apply, and there's also policy requirements that plans may have adopted. So going back to the example for LA City, if you're dealing with a plan in LA City, you'd want to look at the gift law at the California state level. You'd want to look at the gift law at the LA City ordinance level, and you'd also want to look at the particular policies of that plan that you're dealing with. Here, again, it's also challenging like the lobbyist requirements because there are formal and informal positions. These laws do change often, and there may be contractual obligations for you to follow these laws, because a lot of times the laws do relate to governing the behavior of the recipient opposed to the behavior of the giver. But as a private party, interacting with the government official, you may be brought into that law and have to comply with it pursuant to your contractual provisions.
Sonia, one question here. Are the gift regulations and statutes, do you typically find these in the same place where you find the lobbying regulations?
So a lot of times I feel like I will be giving you unhelpful responses here. And so I'll give another unhelpful response, which is not always, but sometimes. So these laws could be found next to the lobbyist laws. They could also be found in the area where it's governing government conduct of officials, because it is generally a law that applies to the recipient. And so one rule of thumb, if you're looking at what laws apply and trying to find them, is just search for the word gift or value, and it should lead you to the applicable laws that way. So next slide, please. So like I was mentioning, there's multiple layers of requirements. There's also, headline risks associated with giving gifts, and there may be heightened restrictions for lobbyists. And in addition to whatever the state law or local law is, as well as the policy requirements, you also would want to consider your own policy, because more than likely, as an investment advisor, you're going to have policies and procedures on giving gifts. So you also want to stay in compliance with your internal operations. And I also think it's important here to maintain a record of the gifts.
Yeah, Sonia, when we think about, when I think about record keeping, I think about the Advisors Act Books and Records rule, but it sounds like, based on your experience, maintaining a record is also important because of the states may come back and ask about it, right?
Precisely. I mean, these laws are often reactionary, so you never know what scandal is going to happen in a couple of years. And in maintaining records, it's important to do this because I have seen this arise where it's on a look-back basis. In the state of California, the Attorney General was doing an investigation of certain government officials at a plan to make sure that these government officials reported their gifts accurately. And in order to verify that, the state went to all the vendors, the advisors with that plan and said, okay, we want to see your records for the past 4 years in terms of who you met with, what occurred at those meetings, and if anything of value was given. So for that reason, I think it's really important to maintain a record of any meeting or any other type of interaction, including the date, who attended from both the advisor side as well as from the plan side, if anything of value was given, and if anything was given, what was that? And then what was the per person amount? And this should include anything of value, quite literally. So cups of coffee, bottles of water. We had a client who was trying to remember if 4 years ago, the receptionist validated the parking for some people who came to an on-site meeting, just because the receptionist would always validate parking for anyone that parked in the building. But that could be deemed something of value under the gift ordinance. And then even if nothing was given, at least you have a record that nothing was given, and then you don't have to spend time researching that in the future. So next slide, please. So here are a couple examples of different laws. And one thing to remember is that these are regional based laws. So I like the Florida law here because it does include plants and flowers as a gift. So I have to believe that there was some type of scandal involving, an exotic orchid in the state of Florida, which led to these words being inserted into the statute. And this statute is also important as an example because it does show the heightened requirement for lobbyists, and it also has a heightened requirement for anyone who would be contracting with the plan. And so it's a heightened restriction for those individuals. And then the next example here is Wyoming, which, a gift is very, very broadly defined of anything of value, but then there are some exceptions, including a gift doesn't include food or beverages, or gifts of, $250 or less. And the next slide, please. And then this slide is a good example of the layering issue that I discussed earlier. So here there's Texas state law as well as the El Paso city ordinance. So if you're dealing with somebody in the city of El Paso, you'd want to look at both state and city laws here. And you'll see that they're slightly similar in the extent that they have, a monetary threshold on the value, as well as an exception that relates to conferences. However, both of these requirements or exceptions, play out slightly different. So they're not written in a consistent basis, and you would need to, just make sure your behavior fits in both of these requirements to the extent that they both apply.
It seems like with these gift laws, it seems like they're often very broadly written, but then they've got carve-outs or exceptions built in, right? Is that often?
Yeah, that's often the case. But then I will, just kind of give a preview for with respect to Desiree, is that even if there are these exceptions here, you still want to be mindful of the headline risk. And so I'll move on to the next slide. And so similar to the lobbyist laws, there's a way of thinking about these laws if you're analyzing them. So first, is there a prohibition on the giver or the recipient, which in some respects doesn't really matter because usually, you'll have a contract that will bring the law to apply to the giver. And plus you don't want the recipient to be in violation of the law because that just doesn't look good on your part. Next, what is deemed to be a gift? Are there carve-outs for specific activities such as attending a conference? Next question to ask yourself is, are there any limitations on the amount? Are there any, or is it just a blanket prohibition? So frequent carve-outs could be the de minimis amount, materials, refreshments offered to everyone, or something's given in connection with the meeting. The next question to ask yourself, does the recipient matter? Meaning, is there a different restriction or requirement based off of whether the recipient is, an officer, a trustee, or just a general employee at a plan? And then the requirements or the thresholds could vary based off of these different categories of people. And then finally, are there any disclosure requirements? Typically, there's not a disclosure requirement unless you're a lobbyist or the gift is above a very high threshold, such as $500, but just something to be mindful of when you're analyzing this issue. Next slide.
So I can take this one. As far as, some practical considerations, and I would say gifts, but also lobbying, obvious, the first one's obvious, building things into your policies and procedures. But this next point, and Sonia's mentioned this, but what are the contractual requirements? Because what can sometimes happen with these state and local plans is they'll build language into the contract that adds some additional requirements on. So you need to make sure that you're involved with that process so that you understand, what requirements are in place that way. Certainly pre-clearing of gifts and entertainment can be useful here. Also reviewing expense reports. And the reason for that is that people may not understand, oh, wait, I spent money on this, and that triggers the local gift rule, or that triggers the provision in the contract. So reviewing those expense reports can help catch things that maybe didn't get reported through the pre-clearing process. And this highlights the need for effective training. And Sonia, I think you're going to talk about using some real life examples here.
Yes, I will. Thank you, Sarah. And this also relates back to the earlier point I was making about, just the things that you may not actually think about are a gift, which would be your parking validation or a cup of coffee that's taken from the vending machine and next to the conference room. These are just all things that people should be mindful of. And instead of just going over, kind of what the boring law is, I think it's always better to give examples when doing training so people really understand what the practical implications are. And finally, you also want to consider your record keeping. And then I'll just give an example here too related to the headline risk item here, which is that, just because something is permissible doesn't mean it's a good idea. We had a client who, and this is with respect to the pay-to-play law, but they received a legal opinion from a law firm that said that a wife of an individual who worked at an investment advisor, that it was fine for her to host a fundraiser for a candidate who happened to, be in charge of a local public plan. I think it was a sound legal opinion. It made logical sense under the law. However, when it hit the newspaper, it didn't make logical sense to anyone. And I can tell you, out of all the articles I read on this, no one mentioned the legal opinions because, quite frankly, nobody cared. It just looked bad. And so with that, Sarah, did you have anything to say out here?
No, I would think, in terms of gifts too, it's a challenging area because of all of the, overlapping requirements plus contractual requirements. So like you said, it's just good to keep all those in mind. And even if it's permitted, is it something that you're okay having public?
Yeah, precisely. And I know Desiree is the expert on the headline risk issue.
I think you both said it well, and that's exactly right. And it's the reason I think gifts are unique in this context. You may, you're in compliance, but that's irrelevant potentially where there's a headline risk or where optically something looks amiss. A fancy dinner that falls under a carve out, an exception, but still from kind of the public perception point of view, was excessive or, could have been influential in sort of an improper way. So I think what Sarah said is really helpful here. Think about what your tolerance is for the headline risk and what you would be comfortable with seeing in the public domain, even if technically you're in compliance. To Sonia's point, if it rises to the level of landing as a headline, the nuances of the law or the fact that there's a carve out in a local law is not as compelling as the fact that it occurred, right? So if you're exchanging hands in public, receiving a fancy orchid, for example, and you're not in Florida, that might well be okay, but you want to think about kind of the optics of that, or whether you're the giver or the receiver, what does that look like? And what story, what narrative will that tell? And can we weather it? And it might be that you can, but oftentimes it's prudent to be overly cautious so that you don't have to explain on the tail end that, in fact, you were in compliance and that was an appropriate kind of gesture. So I think it was well said by my colleagues here. With that, next slide, please. We will transition into placement agent considerations from here.
Great, thank you. So I'll breeze through this so we can get through the presentation and just highlight a few issues here, which is, there's different levels of requirements. And a lot of times, even if placement agents, the use of placement agents is okay under the state or local law, the plan may have its own prohibition on placement agents. So you really want to make sure you understand what the plan's policy requirements are. And then another thing that confuses people sometimes is that just because a plan wants information about a placement agent doesn't mean it's banned. Rather, it's just a disclosure item. So you want to understand between a ban and a disclosure item. For the next slide, and this is another item that confuses people as well, because, and this is also an example of how these laws are not quite drafted for the industry, which is that an internal marketing person at an investment advisor may be deemed a placement agent. And that is confusing to people because that's not how we think about it typically in our world. And I'll go to the next slide.
And Sonia, one question here is typically you see this more in the private fund context, is that correct?
Correct, yes.
Thanks.
And then California is an example here, which of placement agent that would be defined to include your internal marketing persons if they fit within this definition. And then finally, for the last slide in this section, with respect to payment would be, is this a disclosure item or is there a prohibition? And this gets back to that contingent compensation. Some plans may prohibit contingent compensation, others may just want to know about it. So it's something to understand in advance. And then I'll turn it over to Desiree now.
And next slide, please. So, this is sort of another headline risk interlude, but given the nature of their work, I think what we see, and particularly with the definition that tends to be a little bit more broad or beyond the scope of what you might typically think, placement agents as defined can sometimes be at the center of a potential headline risk, right? In order to be successful and to raise capital or to raise awareness, placement agents have to be able to liaise with potential investors, sometimes at a rapid fire pace as things may be. So if a placement agent is preparing marketing materials or targeting strategies, there's an additional component of written work that ostensibly kind of speaks for the fund or is kind of a public facing opportunity that we need to be mindful of and that we need to be thinking about. And kind of in order to run afoul of the regulations that Sonia and Sarah have helpfully set forth, I think it's important to understand and determine who is authorized, right? And the extent of authorization. Let's get a lot of clarity around who we're regarding as placement agents, depending on the definition, depending on where you are. In California, it's your internal marketing people as well, just by way of an example. So determine, who that universe is, and then who's authorized to speak, and the extent of that authorization. And this goes hand in hand with the messages that you're communicating and what's permissible in your jurisdiction. We'll talk about this in a moment, that kind of interplay between facts and law, and that's key in the a kind of strategic legal communication space, in the crisis communication space, but right, who's authorized, the extent of that authorization, and then what is permissible, what is legally permissible in your jurisdiction. And then from there, you can establish your tone and your point of view, which is part and parcel of the placement agent work. But we want to be mindful that we understand the parameters around it before, kind of creating an external dialogue that could potentially create, problems down the line. So I think those kind of, that sort of quick rubric should give you an idea when we're thinking about placement agents and headline risk, right? How you can kind of control it, how you can keep the narrative contained, by thinking a little bit about each of these elements and making sure that what you're saying is permissible at the outset, right? And establishing your tone and point of view from there. Next slide, please. From here, we are going to talk through a number of other issues to consider.
So I'll get us started with the Advisors Act pay-to-play rule. And that rule imposes a 2-year compensation ban if an advisor or its covered associates make political contributions above a certain amount to officials of state and local government entity clients. And on multiple occasions, the IAA has explained to the SEC that this rule is unnecessarily complex and it imposes significant penalties on a strict liability basis. And we have suggested a number of changes to this rule to the SEC, including reducing that 2-year period, increasing some of the de minimis contribution exceptions, and other changes. So just wanted to mention our work in this area.
Great. Yeah, thank you, Sarah, because I think that work is important because this rule does trip up a lot of clients. And these are clients that aren't intending to do anything wrong, but it's just that the rule is so broad. And unfortunately, in addition to the SEC rule, there are also other pay-to-play rules at the state and local level. So you need to be mindful of those rules as well to the extent you're working in a particular jurisdiction. And then there's also practical considerations, just going back to the example I gave earlier, the legal opinion, how do these campaign contributions look if they do hit the front page of the newspaper? How are you going to be able to defend them or make it seem like that was a good idea at the time? Next slide. Oh, sorry, Sarah.
One thing I just want to mention, please feel free to submit any questions through the chat function. And so happy to take those. Thanks.
Yes, because I know this is a confusing area, and another confusing area would be the FOIA related issues. And we just want to mention this just briefly here, which is that anything provided to a plan potentially may be disclosed. So you really want to understand what the law says, as well as what the exemptions are, which typically would be a trade secret. And just be mindful of that before you submit information to a plan, not thereafter. So you don't have to scramble unnecessarily. Next slide. So this slide is another thing to be mindful of when you're dealing with a plan, which is that it could lead to disclosure reporting obligations. It could be a state or local requirement. You want to understand who needs to report. There is one form in California, the Form 700, that sometimes plans will require not the advisor itself, but rather individuals at the advisor to file. And this filing would include an individual's personal assets, their investments or real estate holdings in a particular jurisdiction. And that information is publicly available, which a lot of people don't want to be publicly available. So just be thinking of this as well in terms of who's interacting with the plan. So you would minimize the number of people who may need to fill out this form.
Sonia, too, this seems to highlight the need to, and you mentioned this earlier, but keeping track of interactions. So on both sides of the interaction, who at the advisor is talking to the plan and who at the plan are they talking with, right? In case there's reporting on both sides of that, it seems like it's helpful to keep track of that.
Exactly. I mean, we had a client who accidentally got caught up in making this disclosure reporting because that person just happened to be the person that signed the contract that day. And the plan said, well, we want to get this information from you. And it just so happened that person was involved in litigation and didn't want their personal assets being publicly available because that would have, impacted their litigation on a completely different matter. So you definitely want to try to minimize your risk here in terms of what is being reported. And one way to do that would be to minimize the number of people in your organization that have contacts with the plan. And I'll turn it over to Desiree now to talk about the next slide.
Thanks, Sonia. So, okay, we've said from the outset that headline risk is a consideration throughout, and whether you think of it as kind of a layer on top or a layer underneath, it's something that we should be mindful of, as we navigate some of the regulations that Sonia has helpfully shared here. We talked about gifts, placement agents, non-compliance with registration. What can we do in advance so that if we do run afoul of a regulation, if we have some other type of crisis that we haven't talked about here, anything from a data security incident to an employee issue, how can we navigate that in advance so that we're well positioned to address it on the back end? And this should come as no surprise. Planning is key in the crisis space. Oftentimes the backlash on the heels of a crisis stems not from the crisis itself, but from the response, the way that an organization kind of took that crisis and responded publicly or responded internally with key stakeholders and employees. And so having an incident response plan in place ensures, or at least gets us closer to where we want to be when a crisis hits. It ensures that we have some preparation, some preparedness around managing a crisis. And part of your planning starts thinking about the risks for your particular plan. So every organization is different, every advisor is different. What are the risks that you might be facing? And sort of workshop those out, think about those, and think about, what might actually rise to the level of a crisis and what might not for some organizations, right? I'll give an easy example, but clients will often come to us and say, an employee posted X on social media, and this wasn't something that we wanted public. Now, in some instances, that can be very devastating, depending on what it is that was shared that we didn't want to be public. In other instances, it's minor, it's really insignificant to kind of our underlying business operations. And so think about what truly rises to the level of a crisis, what really is a risk for your particular plan, and then understand the law around those risks. And this is where Sonia comes in with her expertise and Sarah with really good expertise. If we understand what the law is, we'll know kind of where that line is. If we're running afoul, if the risk rises to the level of an incident that has regulatory implications or that needs to be reported or shared in some way. So getting our arms around what is a crisis, what are the key risks, is critical to your incident response plan. The other piece of your incident response plan that is helpful in the face of any type of crisis are draft statements that would facilitate a quick response in the face of a crisis. We're not necessarily going to know in advance what crisis we might face, although doing that preparatory work that I just described, thinking about those risks, is helpful, but we won't know what's actually going to hit. But if we can create a draft statement where at the very least, we've thought a little bit about what our core values are, right? What do we want to communicate at the end of the day? Because it's never advisable to dwell on a crisis in the face of a crisis. Even if you're called to respond, you'll want to thoughtfully address the crisis and then pivot to your core values. So if you've started with a statement that indicates what is important to your organization, what are your core values, why do you do what you do, that is ready to go, right? And then it's just a little bit of plug and play so that once, if a crisis hits, you can quickly gather the facts, determine what the law is so that we understand where we land with respect to, compliance, non-compliance, regulatory reporting requirements, if we have those, whatever it may be. Facts, law, and then feelings as the third component. What do we want the public to take away? And when I'm saying the public, sometimes it's truly the public. We're responding to, the New York Times that has, an inquiry and is calling for a statement. Sometimes it's just internally to our employees if it's sort of more of an internal non-regulatory matter. Either way, know the facts, know the law, and then decide what feeling you want around that as you issue your kind of strategic legal communications. And then we pivot to our core values. So that core values piece, which should take up the bulk of your crisis response statement, can be drafted in advance. And then you can, as I said, kind of plug in the rest of the statement so that you're responding quickly, cohesively, and so that you already have an idea of what the potential responses are going to be, meaning that core values is what people really should be responding to if you've done it correctly, or at least that should resonate along with the quick response to the crisis. So again, as part of our incident response plan, we're thinking about the risks, we're drafting our statements, and then we're thinking in advance about our communication strategy. Who is going to speak? Who's authorized to speak? Do we have a media spokesperson and a social media liaison? We want to be sure that we aren't disseminating sort of competing statements or multiple statements that haven't been vetted. So coming together, this is one of the most helpful things that you can do in advance of any crisis, right? Before there's even a crisis on the horizon, is think about who is authorized to speak so that in the event of a crisis, all communication is being funneled toward that one person or department, and we're not kind of tripping over ourselves and saying things that are either contradictory or inconsistent or otherwise. The other very helpful thing that you can do literally today, if you don't already, is start to monitor things that are important to the plan at issue, the investment advisor firm at issue, key stakeholders. You can monitor media and social media, and there are free and easy tools. You can partner with counsel. This is something we do for clients all the time, is monitor what media and mainstream media and social media are saying about you, so that you know what the tone and tenor is, throughout, right? You know what your baseline is. And that way, if there is an incident, you'll know is there sort of public outcry around this, or, was that dinner not really perceived as running afoul of gift laws? Is this non-compliance going to be front page news, or is it not, landing at all? So monitoring helps us understand what the non-crisis landscape looks like. It helps us understand if there is in fact a public crisis of some sort, as I said, public outcry, sort of industry term. And then we can respond if warranted. If it rises to the level of a crisis, which you've assessed, at the outset of your incident response plan, we can respond quickly with our core values statement. We can respond through a designated person because we have our communication strategy in place. And we can respond without delay. And respond quickly and respond without delay sound like the same thing. Typically, what I think of is respond quickly, meaning internally, all of our ducks are in a row, and then we can respond externally without delay to media inquiries, social media, traffic and chatter, and otherwise. So this is the rubric for a pre-crisis incident response plan, or considerations. If you haven't gone so far as to create a plan, considerations that you can lock in at the outset so that if there's a crisis, you're well prepared. Next slide, please. And then crisis management without an incident response plan. We put this in because many of our clients come to us where they're in this exact scenario. They haven't in advance thought about how they might manage a crisis, and that's fine. We are certainly accustomed to that, and you can recover even without an incident response plan. And so it's better, but if you're faced with a crisis, there are ways to navigate that as well. Again, move quickly. I said this at the beginning, I'll say it again. That is the key factor in how, even from a regulatory standpoint, oftentimes, we're perceived to have responded, whether we responded well or, maybe insufficiently. That quick action is really important. With that said, you want to be prudent, and you don't want to say something or react before you know exactly what has happened. So, we'll lock down communications until we know the facts and we know the law. As I said before, this is especially important if you don't have an incident response plan. You might not have thought about the entirety of the landscape. What are the local laws? What are the state laws, federal, et cetera? Let's get our arms around that quickly. And let's also get around the facts at the same time. And so that those align together. And then from there, remediate. What are you going to do to remediate? If it's a C-suite disgrace event, are you terminating a CEO? Are you asking that CEO to step down? If it's an employee, internal threat actor, are you terminating the employee or putting them on leave? Let's come up with a plan to remediate. And And that way, when we prepare our statement that has our core values in it, we can either, address the crisis, distance ourselves, explain and take ownership of the issue, but that remediation can be part of our response so that it's clear that we're being proactive. Then in terms of the regulatory implications, if we have run afoul of some of the things that we've talked about today, we want to think about the timing, right? Are we on the clock to notify regulators before we notify the public, or is there a contractual obligation that we have to notify a business partner or stakeholder before we make a larger statement? Or maybe we want to say nothing at all, and that's an appropriate crisis response. But we're moving quickly, we're making determinations about facts and law, we're remediating, and then we're preparing that statement, which we can either use or hold depending on what's appropriate in the moment. And then critically, for any crisis that arises, is that we want to get in a position where we move forward and get back to business, and we've contained it so that it doesn't stay with us going forward. Next slide, please. With that, key takeaways.
Great, thank you, Desiree. So, some of these I'll say we've talked about it already, but I think it's helpful just to conclude with them in terms of, first of all, initial considerations when you're thinking about dealing with a particular plan. So before you respond to the RFP or discuss engagement with a government entity, you'd want to determine what laws, policies, and disclosure obligations apply. Also confirm if any political contributions would preclude the investment, or at least getting paid with respect to that investment. And then prior to engaging a placement agent, confirm if using the placement agent was okay, as well as what type of fee arrangement would be okay to do or would be prohibited. Next slide. And then with respect to ongoing considerations, you definitely want to take affirmative steps to continue to monitor these different rules because they do change often, like we've talked about, and these changes are often reactionary. So if there is a scandal tomorrow in Wisconsin and people end up going to jail as a result, I can guarantee you, or I would put money on the fact that within the next 2 years, the state of Wisconsin is going to have some type of new law or policy as a result of that incident. And then you'd want to just maintain record-keeping policies to comply with any new requirements, and also just to think long-term in terms of if anything is reactionary, you need to disclose something in the future to a regulatory agency. Next slide. Great, thank you. Other ongoing considerations would be, based off of what the laws are changing and how just discussions are going in the public. You may want to update your policies and procedures as a result. And then also just generally, given this presentation today, you may also want to require pre-clearance of all political contributions and gifts and entertainment, so you may stay on top of that.
Sonia, one question on that pre-clearance. We do sometimes get questions from members about whether they should pre-clear all political contributions and gifts or just those above a certain dollar amount. And it sounds like you suggest doing pre-clearance for all, is that right?
That's correct. I would definitely recommend that because this is a sensitive area and you don't want to trip yourself up. And plus there are changing requirements here. So this is a good way to stay on top of a rule that before someone goes out and interacts with a plan, you can make sure that what you have down for the laws of that particular jurisdiction are still accurate.
Right.
Then,
I would also say here, just like other policies and procedures, a lot of this is going to depend on the scope of your business. So if you're only doing business in one, with one plan and one jurisdiction and you're keeping on top of that, that's one thing. But if you're going to be doing business across a number of jurisdictions, then it certainly makes sense to, think about pre-clearance for everything because of all the changes in this area.
Correct. Yeah. And it's also, these rules are confusing. I mean, I think your compliance officer would get confused as to how to navigate the laws for a particular plan. So if your compliance officer is confused, then I can assure you that your internal marketing person is going to be confused as well. So this is just a way to, make sure that everyone's complying, even if the intent is, because like I said, there is a lot of confusion. And then also, as we touched on earlier, that giving something or either a gift or a political contribution may be perfectly okay, but this way you can assess the headline risk at the time as well. And then I'll move on to the next slide. Thanks. And so, final considerations here would be, prior to hiring a new employee, you would want to require disclosure of all political contributions, as well as gifts and entertainment provided to any state or local officials. This may not actually fall within a requirement of any law, but I think it's useful because then you can get an idea of the individual and what their prior history is, who they've been interacting with. You can see if maybe there's something that you would want to monitor that person for. If they've gone out in the last couple of years and given a lot of gifts to people, you'd want to stay on top of that person. And then for all personnel, you'd want to educate and continue doing trainings. As we talked about before, it's really useful to do trainings with real life examples so people really understand how these requirements work. And then control who interacts with the plans, as we discussed before. You want to make sure that you have maybe like a set group of signatories or individuals, and this is also going to be based off of your jurisdiction or your organization and how the scope of the organization is organized in terms of what people's role are. But to the extent that you're able to minimize the number of people that are in contact with a particular plan, that's going to minimize your headaches in dealing with complying with those rules. And then finally, the last headache to deal with is headline risk. And so I will turn it over to Desiree to conclude.
Thanks. And I think I've kind of said my piece here, but it's something to be mindful of throughout. And if something feels amiss, it may well be. If something feels like it could put you in potential risk of landing on the front page of the New York Times or a lesser but still important platform in your industry, I would be mindful, think about it, make sure that you're prepared to navigate and to weather it and avoid it if you can.
All right, well, thank you very much. Thank you, Sonia and Desiree, for a great presentation today. And thank you all for joining us.